day, the proceedings involving the former President Jacob Zuma, his legal team arguing that Billy Downer is not fit to be the prosecutor, the NPA arguing against that. Romeo Nthambeleni is a legal analyst. Karyn is a legal journalist. Good afternoon to you both. Thank you for your time. Let me start with you, Karyn. For much of the day, Dali Mpofu and Tabani Musuku making claims about Billy Downer, and then as soon as he stood up, Advocate Wim Trengove for the NPA seemed almost, I suppose, angry at the claims that had been made against Downer.
I mean, I think his opening words were that he was basically shocked, or I'm not sure the exact term that he used, but he essentially said that the tone of the attacks on Downer had been defined by hyperbole and false claims, and that, misrepresentations. He went through a number of the arguments or the evidence used by Dali Mpofu to substantiate his averments that Billy Downer did not possess the required, impartiality and independence to be able to prosecute Zuma. And said that, much of what Mpofu tried to use as evidence against Downer was in fact evidence of his integrity and what he called his guts and courage as a prosecutor. Now, we know that Jacob Zuma's lawyers have focused in on the fact that Downer, for example, fundamentally disagreed with the state's stance in the spy tapes case, making that very vocally apparent in April 2009 when Mokhachedi and Shea announced that the state would drop charges against Zuma on the basis of the spy tapes, and had retained that consistent position, and said that he had been asked by the NPA to provide an affidavit about his particular position on the matter, which he had done. Now, of course, Zuma and his lawyers have argued that essentially he was siding with the DA at the time when they brought an application. Trengove and actually also Judge Kuhn to a degree saying that, Downer's stance on the case had actually been vindicated by the spy tapes judgment. And certainly while he was shocked and horrified by what was revealed when those spy tapes recordings were played, there's simply no evidence that he was aware of it at the time that it was happening.
Romeo, how do you assess this argument? Strong claims made by Zuma's legal team, and then really, I suppose, a strong defense, almost, for Wim Trengove, almost an emotional defense of Advocate Downer.
No, Steve, I didn't get you clearly.
I was saying that it was a strong set of claims from Zuma's lawyers, and then quite a strong defense from Advocate Wim Trengove for the NPA.
Yeah, I totally agree with you, Steve. I think what is important here is the question whether Billy Downer has the title to prosecute, and the interpretation of the provisions of Section 106H of the Criminal Procedure Act. And I think what is important here is whether the legal team representing the president is making out a proper case on whether Billy Downer has a title to prosecute. And as Karyn has actually said it correctly, there were muddled allegations that were being put, but the question is whether Billy Downer has a title to prosecute, and whatever which was being said actually talks to him having the integrity as a prosecutor. And the mudslinging of him having been in a case for a very long time does not actually say he doesn't have the title to prosecute the matter.
Romeo, when lawyers make claims about other lawyers in court like this, at one point there was this sort of allegation that, spies had been directing the NPA and that Downer must have known about this because, and this goes back years, because of the conduct of Leonard McCarthy. Can a lawyer just say that? Do they have to give proof?
No, it's correct, Steve. You cannot just make bold allegations in court. And you can see that, when you make that kind of allegations and when you make submissions from the bar, the judge does not appreciate that. You cannot bring evidence that is not actually tested. So what ought to have happened with these complaints? They were supposed to have been reported to the NPA itself, or even to the Law Society then, now the Legal Practice Council, regarding the conduct of the prosecutor, if they were actually unhappy with him, and how it will infringe on his constitutional rights to a fair trial. So because in the nature of our prosecutorial authority, it is not a sin for a prosecutor to want to win the matter. That is, the basis was laid in the Porritt case by the Supreme Court of Appeal to say it's not a sin for the prosecutor to pursue the case with a vigor to actually win. So what is coming out in that argument is that at all costs, Billy Downer wants to win the case, and that is the duty and the function of a prosecutor and the prosecutorial authority in terms of the act. That is what he ought to do.
Karyn, there's also this argument around whether the NPA should have access to former President Jacob Zuma for a medical examination. Zuma's legal team seemed to say, if I heard them correctly, that the NPA had arrived at a hospital and tried to examine them. The NPA says that's not true. What do we know about this? What actually happened?
Well, the averment from the NPA is that the doctors or the NPA had written to Jacob Zuma's attorney to ask him to arrange for them to conduct an examination. And of course, this is in line with the court order that was previously granted by agreement between Dali and Mpofu and Vim Traingrove and ultimately made an order of court by the judge that the NPA were entitled to appoint their own doctor and to have Jacob Zuma examined. But Dali and Mpofu's position is that that examination was contingent upon the former president bringing an long application for a postponement or raising issues about his fitness, in which he potentially would raise issues around his fitness to stand trial. Now, the contention of the defense is that no such decision has been made, that Jacob Zuma remains hospitalized, but that his doctors have effectively said that they need more time to make a determination as to his future progress and the stability of his health. We know from Traingrove that based on the information that the NPA doctors have been able to get from the defense or the relevant authorities, they have made a determination that in fact Jacob Zuma is fit to stand trial. But all of this is very much a question that appears to be in limbo. And I think that's why Judge Kuhn made the decision that he did to not force the matter by granting an order that would compel correctional services to hand over those records and essentially put that matter on the back burner so that the special plea could be heard, argued, and ultimately decided. Because clearly this issue around the former president's state of health, whether indeed he's going to bring some form of challenge linked to his fitness to stand trial, is going to be an issue that once it is dealt with, or once it comes into play, if it comes into play, will have major implications for this corruption case. And it's very clear the judge just wants to get things going at this point.
I mean, Romeo, this issue is definitely going to come back. I mean, I would say it's likely, let me put it like that, it's likely this issue of a former president's health comes back. How does a judge assess something like this? I mean, no one sort of, the lawyers are very polite, but essentially it seems the NPA just doesn't trust the military doctor that is assessing the former president. How does a judge deal with that?
Yeah, you're correct. Hence, you saw that there was a subpoena that was sent out to subpoena McCarthy to be present in court and the doctors to actually get ready to make a final determination if ever there was an issue of a postponement that was going to be argued. Karyn is correct that the defense then made a 180-degree turn and said that we are actually not going to go there. He's going to actually proceed. But what is interesting, Steve, is the following, the development of what was happening in court. Previously, they were the ones that were arguing that the matter must not proceed in the absence of the former president. So they were saying that his rights to fair trial and his rights to being present in court are secondary to this matter. Today, they made another attempt to say, no, he can actually appear virtually, then they can exchange messages to him. But that is what the judge was saying previously in relation to him being in a correctional services facility. So you can see the kind of litigation that is actually going on in court in relation to how this matter is being handled. When the NPA is ready on the other side, then there is a complete turn of events that actually takes the other side by surprise. Also, the submissions that were being made today that were not also on record on their papers, which will not take the matter any further whatsoever.
It would seem that this is going to be quite a long argument. Karyn, are we going to have a full day in court tomorrow? I mean, Dali Mpofu and Tabani Masuku, the advocates for the former president, they'll get a chance to argue again?
Yes, I mean, It is starting at 11 o'clock, and I think the hope is potentially that it will be done by lunchtime. But given, the kind of contentions that were put on the table by Trengrove and the obvious disagreement of the defense in relation to those matters, I think that they will take their time to respond, because essentially this is an application which, in the former president's view, should lead to the entire decimation of the case against him. He's not just bringing a challenge that seeks the removal of Billy Downer as the prosecutor. He's essentially saying that the entire NPA does not have title to prosecute him. And, of course, Trengrove today in court making it very clear that because the NPA is constitutionally mandated to prosecute crime in South Africa, such an application of the Criminal Procedure Act to say that it doesn't possess title to prosecute in these particular circumstances was simply legally unsustainable. We know the state is, of course, making, saying that, this case is absolutely, essentially legally ludicrous. But it's very clear that, if the former president does not get the relief that he wants, it's very possible that there will be an appeal and further processes going forward from that. And I think the real question is, what does Judge Karyn do if he does indeed refuse this application, which he's almost certain to do, and there are subsequent appeals? Does he continue with the trial, or will it be simply delayed and mired in delays and postponements because of these question marks over the former president's state of health?
Karyn, legal journalist, Romeo and Nthambeleni, legal analyst. Thank you both. I do appreciate the time.